Welcome to this week's installment of Rochelle's Daily Wire Video Edition. This week we're going to do something different. Rather than forcing you to listen to me for a few minutes, instead we're going to interview one of the leading figures in the bankruptcy community. So sit back, relax, and let's learn something about bankruptcy law. We are coming to you from the ABI's Winter Leadership Conference being held in beautiful Scottsdale, Arizona, where uncharacteristically it was raining yesterday, but it even rained sometime in the desert. So here in the desert, in the next few minutes, we're going to be talking with bankruptcy Judge Deborah Thorne from Chicago. Prior to assuming the bankruptcy bench in 2015, Judge Thorne was a partner at Barnes and Thornburg.
That's correct.
In Chicago. First off, we have to have some shameless commerce right here because we need to publicize a very important book that Judge Thorne has just updated. It's this book right here on preferences. Now the question is, Judge Thorne, why should people acquire this book on preferences?
Well, if you ever have a client call you and say, we've been sued in Minnesota for a preference case, how could that possibly happen? And you're sitting in the Second Circuit, you can pull out this book and you can see what the law is in the Eighth Circuit on preference defenses. And that's really was the origination of this book.
So it's divided by circuit, huh?
Right, and it compares the most common defenses, new value, ordinary course, contemporaneous exchange, circuit by circuit. And in some cases, I've drilled down a little bit into the bankruptcy courts where it looks to me like there's a change that's coming, that the bankruptcy courts are trying to distinguish something at the circuit level. And so I've noted that. And I guess before I became a judge, I was sort of a preference defense geek. In fact, I think I was known as the queen of preference defenses in a small circle.
I see. So the original edition of this book was a good time before you were on the bench,
right.
Is that right?
I think the first one was probably about 2005. It was updated in 2010, and then we thought it was probably time to do it in 2018.
Yeah. Well, this is a book that you can either buy at an ABI event or dial it up on the web and purchase it online. It's really an excellent piece of work. Gives you a real shorthand about how to get to the nub of a problem in whichever circuit you happen to be. So this is the Preference Defense Handbook, third edition.
And I should add that I was very much assisted this time by my current law clerk and by my soon-to-be law clerk in September of 2019.
Yeah. Well, speaking of law clerks, you have written recently a relatively notable opinion upon, of all things, parking tickets in Chicago. And if I recall correctly, in your opinion, you mentioned that parking tickets represent, 7% of the budget for the city of Chicago. Now tell me, why does anybody give a damn about parking tickets in Chicago?
Well, I can say before I was on the bench, I didn't do any consumer law. But it became apparent very quickly in my judicial career that people in Chicago filed Chapter 13 cases to try to discharge parking tickets. Parking tickets are non-dischargeable in Chicago, and so people have $10,000, huge amounts in parking tickets, which have generally compounded over a period of time, and so they try to pay them off.
Well, now, was discharge the only issue with respect to parking tickets?
The big issue is that the city impounds cars once there's a certain number of tickets and puts them in a pound, and to get the car out, people would go, I think some time ago, would go with the Chapter 13 petition, say I filed, I need my car back, and the city would give them the car back, the 13s would fail, which most do, and then the city really took harder and harder, put more and more pressure on the people who were getting the tickets.
So if I'm getting it, people would file Chapter 13 for the purpose of getting their car back that had been impounded. But how did you and the other judges in Chicago rule on that issue?
Well, originally, the city came in very frequently on a motion to dismiss, saying that this petition was filed in bad faith. And sometimes it was, and sometimes I didn't really always see that there was any evidence that it had been. But the city passed an ordinance at the beginning of 2016 which said they have possessory lien on the cars that they had impounded. And the possessory lien was for the amount of the ticket. So even though the original ticket might have been $200, now it was far more than that, and the car might be worth a very small amount. But at any rate, that was the position the city took by ordinance. And so I then was faced with, sometimes with saying this was a preference, but there were cases filed, and I wrote an opinion earlier this year saying that the city could release the cars and still maintain their possessory lien.
But they had to release the cars.
They had to
right?
release the cars. The Seventh Circuit has told me that. It's not original with Judge Thorne. That was from the Seventh Circuit.
Has the city of Chicago just rolled over and played dead after your decisions, or
No,
are they going up with it?
The city and the debtors jointly certified the case for a direct appeal. And my
to
case
the Seventh Circuit,
to the
right?
Seventh Circuit, and my case and about 3 other cases, which all said that the cars had to be returned, but for various reasons, a little bit different than mine, those are all consolidated at the Seventh Circuit now.
I see. Now, who is representing the consolidated debtors at the Seventh
My
Circuit?
predecessor, Gene Weedoff, former president of the ABI, has taken that case on a pro bono basis.
Well, God bless him. He's, as usual, doing God's work. I'm curious, Judge, is there a potential petition for certiorari here? Is there a underlying circuit split?
There is.
Tell us about it.
The Seventh Circuit in Thompson versus GMAC said that you have to give back the property that the debtor has title to upon the filing.
If it were repossessed before filing.
Right. The Tenth Circuit has said, no, you have to, the debtor would have to file, I think, a turnover action under 541 to get the property back.
And that could take 6, 8, 10, 12
Right,
weeks.
which is a real problem if you are poor and your car that you need to go to work to pay the tickets off in your Chapter 13 is in the pound. So, but the Seventh Circuit had already said you have to return the property. So I was just following the Seventh Circuit. A number of other circuits have ruled that way, but the Tenth Circuit hasn't. I think there are a couple other circuits, and I understand there may be a cert petition coming out of the most recent case in the Tenth Circuit.
Yes, the Tenth Circuit case, I think, is called Garcia.
Right.
And my information is they have hired a very fine Supreme Court counsel to write the cert petition. But I got to tell you, between you, me, and the lamppost, I think the Chicago cases are better candidates for Supreme Court review than the Garcia case coming out of the Tenth Circuit. The prior decision in the Tenth Circuit really was the one that should have gone up.
The Collins case.
Called Cowan. That really starkly presented the circuit split between especially the Seventh
Right.
and the Tenth Circuits.
But it has bigger ramifications than just parking tickets. I think it extends to a Chapter 11 case where property's been repossessed and what happens upon the filing of the case.
Yeah.
In Chapter 11, it may not be as dire or as urgent as it is for somebody's car, but clearly if they're a tool and die maker and they've got a lien on the tools and dies and they've taken them back and the car can't get produced because of that, it's dire as well.
Yeah, well, it could. I think the issue is, it's important for individual debtors in 13, but it could kill a Chapter 11 case. And also, by the way, I think there's a subsidiary issue, is there not, whether or not liens can attach after bankruptcy, despite the automatic stay. It's a tangled issue of how automatic the automatic stay is.
Well, it is
and
a court
what the
order.
ramifications are.
I mean, it's a court order, and I think that, not practicing anymore, but there are ways that a lender who's repossessed can come in on an emergency basis asking for adequate protection. It's probably harder for consumer debtors counsel to get in on every case, but if they had to come in, they'd have to come in on an emergency basis because that's where the revenue is coming from, getting to work.
Well, I tell you, for our audience out there, it's going to be a race to see who gets to the Supreme Court first. The Garcia case out of the 10th Circuit, they're in the process now, as I understand, of writing a cert petition. So chances are, because it's already December, that could likely not be on the Supreme Court calendar until a term that begins about a year from now. Your case hasn't even been briefed yet in the 10th Circuit, so
yeah, I think the Seventh Circuit's given them an extension of time to file the briefs.
Yeah, well, let's hope that we get a prompt decision out of the Seventh Circuit so that more pure issue can be brought to the Supreme Court, because I got to tell you, these are critical issues for individual debtors, and like you said a minute ago, when you use your example of tools being taken away from a company, it could kill a major reorganization.
Right.
This is not trivial.
And from what I hear, the auto supply industry has got some difficulties, and so it is a big issue for them as well.
Yeah, right. And I think we're going to have more problems in the oil patch right now. So repossessed equipment in the oil patch could cause difficulty for service providers as well as for the drillers. Well, listen, Judge Thorne, I thank you very much for your time. This has been very interesting. We went all the way from preferences to repossessed automobiles to cert petitions. So thank you very much for your time.
Thank you.
And we'll come back again and chat about another issue that is in the forefront of your imagination. Okay. Thanks again.
Thank you.